What is the value of self-ownership and property ownership? Well, these concepts are at the very root of liberty. Without them, people are treated as subhuman, and their inherent rights are violated in favor of greed and tyranny. Let's look no further than how badly Native American people got screwed over by the government and the US Supreme Court in particular in the case of Johnson v. McIntosh, decided in 1823. Welcome to the Fox Hollow. My name is Skylar and this is Legally Drunk, the show where I get legally drunk and rant about the law. Remember everybody, I'm a lawyer, but I'm not your lawyer. If you need legal help, consult an attorney in your area. Nothing in this video should be construed as legal advice. If you like this content, please like, subscribe, and hit the notification bell so you never miss another video by the Fox Hollow. This evening, I am drinking Liberty Ale by Anchor Brewing Company. They are out of San Francisco, California. Now, grab your booze and let's learn about the law. What are the facts of the case? Well, Thomas Johnson was one of the first Supreme Court justices, interestingly enough, and he bought land from Piankashaw Native American tribes in 1773 and 1775. The plaintiffs were lessees of Thomas Johnson's descendants who had inherited the land from him. The defendant, William McIntosh, subsequently obtained a land patent according to the facts as the Supreme Court accepted them, to this same land from the United States federal government. But, in fact, the two parcels of land did not overlap at all. Furthermore, there is evidence that the parties were aware that the tracts of land didn't overlap, and they purposefully misrepresented the facts to the court to obtain a ruling favoring private sale of land from Native American nations to them, the settlers. Little did they realize that Chief Justice Marshall, sitting on the Supreme Court at the time, also had an interest in this issue. He himself owned land originally acquired by the federal government from Native American tribes. So you can see where this is going. The plaintiffs brought an action for ejectment against McIntosh in the U.S. District Court of Illinois, arguing that their chain of title was superior by virtue of Johnson's purchases. The district court dismissed the claim on the grounds that the Piankashaw were not able to convey the land. The case went up to the U.S. Supreme Court. Justice Marshall wrote for a unanimous court, and they affirmed the dismissal, agreeing with the Illinois District Court. Justice Marshall tried to justify why Native American people did not have property rights by invoking the law of nations in the Constitution, synthesizing international law into U.S. law. He claimed that a thing called the Discovery Doctrine allowed European powers to gain radical title, also known as sovereignty, to the land it discovers. As a corollary, the discovering power gains the exclusive right to extinguish the right of occupancy of the indigenous occupants, which otherwise survived the assumption of sovereignty. Marshall further explained that when the U.S. declared independence from Great Britain, the U.S. government inherited the British right of preemption over Native American lands. The legal result is that the only Native American conveyances of land which can create valid title are sales of land to the federal government. If this sounds like a load of horse crap to you, you'd be right. It turns out that Marshall's reasoning here is on very, very, very flimsy grounds. First, his law of nations analysis is very selective and very flawed. So I wrote an entire law school paper on this one subject in my Native American law class, as I concentrated in international human rights law as well as national security law. So this is kind of my focus area. And that is the fact that widespread international practice by other countries, such as the Dutch, the French, and even Great Britain, was actually private land purchased between people, not acquisition by the government. Marshall inflated this minority practice of government purchase of land to be an example of international law, here referred to as the law of nations, that should be incorporated into our US domestic law. Marshall was wrong, and I fear that he was not accidentally wrong. I think that he cherry-picked this minority example to fit in with the narrative that he wanted to portray with the courts. Second, as you may have noticed, the decision infringed on people's natural right to property ownership, which includes, in that right, the choice of whom to sell your property to. Imagine you're in the process of selling your haunted house. Check out my video about the Ackley Ghostbusters case if you haven't already. But then, as you're selling your property, the government swoops in and says, no, you're not allowed to sell to that person. Actually, you have to sell to us, the government. And if you don't sell your property to us at this fixed low rate, which we set, by the way, then we'll just take your property by force anyway. Sounds like a rotten deal to me. The holding in Johnson that only the federal government could purchase Native American lands created a system of monopsony, which is very similar to the concept of monopoly, which avoided bidding competition between settlers and thus enabled the acquisition of Native American lands at the lowest possible cost, sometimes even for free when the government violated treaty agreements. I'm catching notes of government tyranny from this court case. Lovely. Sometimes you just need to drown your sorrows in beer. That's what I do anyway. Tastes like liberty in a bottle. Okay, so the holding of this case personally benefited Justice Marshall, and on top of it, violated the property rights of millions of people. It is particularly egregious because the Supreme Court could have ruled that any purchase of Native American land was valid, whether by a private entity or the government, and the timing of the acquisition is what mattered, i.e. if Johnson bought the land first, he had the title. But instead, Justice Marshall screwed over generations of Native Americans with his tyranny and greed and this horrible precedent. Finally, as you can imagine, because the case was brought on fraudulent grounds, many argue the ruling should be void for that issue alone, at the very least. What is the legacy of this decision? Well, in Cherokee Nations v. Georgia, decided in 1831, Justice Marshall returns with another inspiring decision. And I'm sure that you can catch the sarcasm. So, in June 1830, a delegation of Cherokee led by Chief John Ross was selected at the urging of Senators Daniel Webster and Theodore Frelinghuysen, pronunciation there, and so it's Chief John Ross and William Wirt, who was Attorney General in the Monroe and Adams presidential administrations, were selected to defend Cherokee rights before the U.S. Supreme Court. The Cherokee Nation asked for an injunction, claiming that Georgia's state legislation had created laws that go directly to annihilate the Cherokees as a political society. Georgia pushed hard to bring evidence that the Cherokee Nation couldn't sue as a foreign nation, due to the fact that they did not have a constitution or a strong central government. Wirt argued that the Cherokee Nation was a foreign nation in the sense of our constitutions and law, and was not subject to Georgia's jurisdiction. Wirt asked the Supreme Court to void all Georgia laws extended over Cherokee lands on the grounds that they violated the U.S. Constitution, United States and Cherokee treaties, and the United States intercourse laws. Justice Marshall and the majority of the court held that the Cherokee Nation was not a foreign nation with the authority to sue in court for its property rights, but instead manufactured the concept of a dependent nation, claiming that native nations were like that of a ward of the state. Yes, it's incredibly infantilizing. Chief Justice Marshall also said, quote, "The court has bestowed its best attention on this question, and after mature deliberation, the majority is of the opinion that an Indian tribe or nation within the United States is not a foreign state in the sense of the Constitution, and cannot maintain an action in the courts of the United States," unquote. The court held open the possibility that it yet might rule in favor of the Cherokee in a proper case with proper parties. We'll see this again soon. Justice William Johnson added, and I don't think he should have added this, but he did, that the rules of nations would regard Indian tribes as, quote, in his words, okay, I'm not the one saying this, quote, in his words, nothing more than wandering hordes held together only by ties of blood and habit, and having neither rules nor government beyond what is required in a savage state, unquote. He is what we like to call around here a racist, like an actual racist, like he's a horrible human being. And these actions had real consequences for real people. But similar to the Attorney General Wirt and the chief of that tribe, we have some good guys. Another breath of fresh air. It's just too bad that they didn't have the majority holding, right? But, you know, it wasn't all bad. There were good people back here, and there were good people fighting for what was right and for real justice. Here's a breath of fresh air. Justice Smith Thompson, in a dissenting judgment, joined by Justice Joseph Story. Yes, Justice Story. What an epic name. They held that the Cherokee Nation was a foreign state in the sense that the Cherokee retained their usages and customs and self-government, and the United States government had treated them as competent to make a treaty or contract. This is all very true, right? The court, therefore, should have jurisdiction. Acts passed by the state of Georgia were repugnant to the treaties of the Cherokees and directly in violation of Congressional Act of 1802. And the injury to the Cherokee was severe enough to justify an injunction against the further execution of the state laws. So unfortunately, that was not the majority holding, but it is one that I can endorse and support. So, 1 year later, in Worcester v. Georgia, decided in 1832, the U.S. Supreme Court came back to rule that the Cherokee Nation was sovereign. According to Justice Marshall, this meant that Georgia had no rights to enforce state laws in its territory against the Cherokee Nation trying to oust people from the land. However, President Andrew Jackson decided to ignore the Supreme Court ruling and instead directed the expulsion of the Cherokee Nation from their land. Hence what I mentioned in another Legally Drunk episode about Andrew Jackson violating court orders. Should the court have its own army? Andrew Jackson seems to think so, because he'd be violating Supreme Court rulings left and right here. So unfortunately, the US Army forces were used in some cases to round people up, and this expulsion and subsequent route is referred to as the Trail of Tears. Of the 15,000 people who left their indigenous lands, 4,000 died on the journey to present-day US state of Oklahoma. These court cases were the foundation for further horrible treatment toward Native American people throughout United States history. Even now, you can see the remnants of this property law violation with reservations, though now at least tribal governments have proper jurisdiction and better autonomy, though this concept of forced dependency on the US federal government still persists to the detriment of Native Americans to this day. As you can see, violation of property rights benefits tyranny. We can see that in the attempt to justify slavery and the ousting of people from their land. You as an individual own yourself. No other people can own you under natural law. You as an individual have an inherent right to property ownership. Our country would have been a wealthier and healthier country had Native American nations not had their property rights violated by the US government. That is my contention. It's Thanksgiving. I think it's important to show gratitude for what we have now in spite of the past. Remember, you are your own person. You should not be punished for the sins or oppression of your ancestors. You are blessed in the modern era to forge your own path and be successful in spite of our dark legal history. For me, I'm grateful for the right to property and self-ownership. I'm grateful that we have this system of governance that can right itself when it does grave wrongs like it has in the past. I'm grateful for the Constitution. What are you grateful for this Thanksgiving? Is it family, a warm home, and food? Let me know in the comment section below. Also, you may have heard something about the recent Supreme Court decision McGirt v. Oklahoma. If you'd like a separate legally drunk breakdown of that case or any other case that interests you, please let me know. Just type it in the comment section below. Thanks for watching. Again, please like, subscribe, hit the notification bell so you never miss another video by the Fox Hollow. Happy Thanksgiving, and I will catch you in the next one. Cheers!